Welcome back and thank you very much indeed. We're still in Ghana Month and today we're in the 5 regions of the north. We're in the Upper West, Upper East, Savannah region, Northeast and Tamalit and all the regions that you can find up there in the north. And I've been joined by my panelists. Kamaldeen Abdullahi is a Deputy National Communications Director of the NPP. Also James Kwabena Bonfair, is a former General Secretary of the CPP, but now he's on his own. He's the editor of a newspaper I'll tell you about very, very soon. And also Sam Jatta George. He is the Member of Parliament for the Ningo Pram Pram constituency in the Greater Accra region. Gentlemen, welcome. Good morning.
Good morning.
Kaula.
Alafi. Kayambiola.
No, I'm locked. It's okay.
Also say Alafia.
Alafia. Thank you. It's Clement Apako has taught me his language. You have not taught me.
I have not taught you that.
You have not tried. You have not tried. Meanwhile, you are my friend.
But as is a Ghana Month celebration ongoing, I would seek permission to at least say something in Dagbani.
Quickly, so that Kabila and then Sam George can also say something. About to Dangbi.
Mpuhore Dagbang Zaha. Yabiya na tinanama ne tabanama tamanama. Won kam Zaha be Dagbang zon dabsulon te puhra ka puhro te taba be nimvo shabambe siyasa puni enya politicians la kazable nyale MPP NDC PNC CPP party kam kana won yacha ay bier puni tzayan jinme ntojina kan bon yelna ka te banti en nan sham ka Ghana karati toni la toni tenan ils ont pour ça comme ça.
Great. Thank you. Kabila. We will start Ghana, on an English note.
Ghana Degbi Hare no metro no ni de nyingme netro he boso kora ya na kuru wi sonta yere jamu kan wa gla topifali puya nesu ya boso kora kan o yakpo nya benpon wubu benpon ne nyina ne kuru wi o ma de potume Ghana Ghana wondu wer ya boso kora do no nsomadi I said the kwa they won't repair kuru wi chaya fini dabwa amen.
Amen. Sam.
Cheme, nyeme me. Lamino wamangana efon lami ne wamabi mau ejomi ke ha Ghana ma kla ne wamabi noyam ha wafon bi kla. Nene pene makwapeji wahane kakepem ne ehin wakpeti. Ne noyam keshwele ke nofiano ne wakamafo chemao enmemio ehane ebamehawo wakonye party ome asechon ne wapoema ma nge lokoji party omeba ne ke wake wamaye nikome alo nikome ani pepe mio wamapoe wagana ma se yehem no kamji wakla wamapeka ke ne wamajoin wagana ma enoyam ne wama eha ebo papa ne ajemasi na abaye noyam na Ghana mami ni amiwa se walika mawo pie wai e ma wo keje hefimi no mi ne wa ma e ma ha ebo papa ke ya ne ma one jo wokla nyechunga
Chani Omanya Blao. So let's begin from Parliament. Sam, I'll begin with you because you're a parliamentarian. What is happening in Parliament now? There seems to be a sharp division regarding the ruling of the Supreme Court in the matter of whether the deputy speakers can vote or not if they are presiding or when they are presiding. You have been one of the people that have been mentioned, or you are one of the people who has been mentioned as having a strong opposition for it. And you say, well, we should wait and see what the showdown perhaps will be. What did you mean by that statement?
Well, once again, a very good morning to our viewers and to my brothers. It's been a while. Friends and brothers who have abandoned their brothers. They should remember that it's a circle, especially for the one at the very end. As for him, he's a bat. He's neither bird nor animal, so you don't even know where to put it. But Parliament it's going to be interesting times ahead. Reason being that we are at a position where, and I think whilst we were waiting to come in, I saw you play a video that's been making the rounds of the first Deputy Speaker, Honorable Joseph Osei, my very good friend, where he made the point that he holds the view, and he was sitting in the chair the day he made that point, that anyone presiding cannot and should not take part in a vote. I mean, Joe Wise himself made those comments just last year. And so to hear him pivot and now paint the picture that it is a right for him to vote. I've heard the president as well.
A respected constitutional lawyer.
I refuse the invitation to treat on that. Because if I decide to go into that, that's a completely different conversation.
I'm not inviting, I'm stating facts.
Well, your facts. But the point must be made. I sit back and I look at where the Supreme Court is inviting us to go. We have massive respect for the institution called the Supreme Court. As to if we have respect for the decisions emanating from it, it's a completely different conversation. I'll repeat myself for emphasis' sake. We have respect for the institution called the Supreme Court. But for the decisions emanating from within that institution, that's a completely different
What's
conversation.
your difficulty with the decision of the court?
The court
You're
is
yet to see the
courts-
reasoning behind the ruling, by the way.
Again, another problem. Our Supreme Court is becoming one where judgments are given and post-facto rationalization is done, because at the time the judgment is given, the Lord Justices are not in a position to tell you the reason behind their judgment. I mean, what kind of counsel is that? That I give you a judgment, but I can't tell you why I'm giving you the judgment. I now have to go and think about why I gave the judgment. I mean, how does this sound normal? If it happens once in a while on cases that have to be expeditiously determined, you'll understand. And now we're even having a situation where you don't even have the reasoning from various individual judges. What you have is one judge sits and writes for everybody. No, that's not how the English jurisprudence we learn from. That's not how it developed.
Can we not change? Can we not decide to have our own tailor-made solution?
Change should be progressive. It should be positive. If you ask me this, I mean, this from the days of Lord Dennings, the Lord Dennings who we copiously quote. If even most times Lord Dennings' opinion has not even been in the majority. His opinion has been dissented, but we have formed legal jurisprudence on his obiter reasoning, simply because even people who dissent put their reasoning on paper for legal students to appreciate it. So right now, if you say everybody, only one person, right for everybody, how is that progressive? You get it. But you see, the point I want to make here is this. You expect the Supreme Court to be the last bastion of hope for the citizenry. And when the citizenry is increasingly losing hope and faith in the institution of the Supreme Court, and the kind of justice delivery that's coming out, and you have monikers now for our Supreme Court like Unanimous FC, it begins to ask the question that is the relevance, importance, and reverence of that institution being maintained.
Are you trying to pitch the people against the Supreme Court or vice versa?
I need not to do that. The court itself has pitched itself against the people.
Why? Because they took a decision.
We're not talking about one decision. And you just need to speak to the people on the ground. Look, we can choose to play political ostrich and political football about it and pretend like we don't know what we're talking about. But look, and this doesn't even have to do with just political cases. Even civil litigation amongst ordinary citizens. People no longer have confidence in our judiciary to dispense justice in the right way. And you've had senior members of the judiciary themselves, former senior lawyers, come out and question the kinds of judgments we see from the judiciary. And it has nothing to do with political cases. I'm saying even civil litigation between persons. I have a land. Kamal has taken my land. When we go to court, people are not even confident in the rulings that will come out, because people have seen, people have heard, people have witnessed. We have had officers of the courts themselves come out and say that the levels of corruption in our judiciary are mind-boggling and unbecoming of an institution like the judiciary. So coming to this recent ruling,
what repercussions do you see?
A lack of faith and trust in the judiciary. And when people no longer have faith and trust in the judiciary to dispense justice, then you are moving to a state of meltdown.
How is it going to affect Parliament? They're working in Parliament.
Well,
We've been calling for consensus.
Coming to this particular ruling that they have given, I've been clear on it. The judges have given their ruling. My leadership has served notice that they intend to explore the possibilities of a review. I wish them well. I personally do not envisage that anything will change, even under a review. They will come back as a unanimous ruling. That is my personal opinion. But that does not. But my leadership in Parliament clearly is going along what the laid down legal procedure is to seek a review. So that's fine. They can go ahead and seek the review. But my personal position is this: Parliament is a master of his own affairs. The president can have his views. The Supreme Court will not tell the president how to run cabinet. So I do not see why the Supreme Court thinks that they can tell the speaker how to run parliament.
Says whatever you do, it must be in tandem with the 1992 Constitution.
Show me where in the 1992 Constitution it says that deputy speakers have a voting right.
Well, he's a representative of his people in Bekwai.
Fantastic. Now, I'll tell you what. The people of Bekwai and Fomina are getting roads and hospitals that the people of Ningo Prampram and other constituencies who are not represented in the leadership of Parliament are not getting. Those are perks and benefits that he gets for being first and second deputy speaker. That the people of Ningo Prampram, the people of Fomina, no, the people of other constituencies like Ladade Kotopon, where my sister Rita Odole had to go and cry at the site of the La General Hospital that has been abandoned by government. The La General Hospital the sword was cut for it. The government claimed they were going to start it. 3 years, they've not done anything. But we've passed under a certificate of urgency, a loan agreement for the people, for the Bekwai government hospital to be completed. Why? Is it not because Joe Wise is the first deputy speaker that we allowed it to go through a certificate of urgency and passed a loan agreement for them? Why have we not done the same thing for Ladade Kotopon? Why have we not done the same thing for Ningo Prampram, where the size of Ningo Prampram has more people than Bekwai, but Ningo Prampram does not have a district hospital? But you are building one in Bekwai. That's the benefit the people of Bekwai get for their MP being first deputy speaker. But it comes at a price. The price is that when he sits in the chair as presiding officer, he cannot vote. He cannot vote. Mind you, the Land Cruiser and that I am paying for from my salary, he gets one for free because he's speaker and gets a saloon car on top of it. So he gets perks for sitting in that office. His salary as an MP is different from my salary because he's first deputy speaker.
Well, but if he decides at some point to swap with the other deputy so that he can also go and exercise his franchise.
No.
What's the difficulty with it? Wrap up on this one so I can bring Kamal.
Our constitution recognizes that there are times when a member of parliament, even though he represents his people, cannot and should not vote. If you take article, I think it's 1045 of the Constitution. Either 1045 or 1105, I'll just check it. It is clear that if me, Sam George, I go and bring an investor to come and invest in Ningo Prampram, and that investor is coming to build a factory, but he needs to get into some kind of agreement with government of Ghana, and that agreement comes to Parliament. It is me, Sam George, who is bringing the investor.
Right.
I'm member of Parliament for Ningo Prampram. It's not the people of Ningo Prampram who brought the investor. Okay. But because I am an individual who has an interest in that agreement, when that agreement comes to the floor, the Constitution of Ghana says that I should not be allowed to vote on the matter. I must state my interest in the business and I must stay away from voting. So it means that the Constitution recognizes that there are times where you will be in Parliament as a representative of your people, but because of personal interest, you would not be allowed to take part in a vote. So it is not correct that the Constitution does not want an MP at all times to be deprived of his opportunity to vote.
I hear you.
So when the MP for Bekwai, who is an MPP MP for Bekwai, is sitting in the chair
and there is a matter that is controversial or a matter of debate or a matter of division between the NDC and the MPP, you cannot tell me that he's a neutral arbiter. The thinking of the framers of our 1992 constitution is that for anyone who sits in that chair, you must be non-partisan, you must be neutral, and that's why they say you shouldn't even take part in the debate. So now if you say he can vote, is he going to take part in the debate? And you know, for want of a better phrase, I'm looking for a better word to help me, but the word that comes to my mind is absurdity. I don't want to say it's absurd, but for the absurdity in the ruling is that the first deputy speaker is presiding. He puts a question and says, all those in favor say aye. And when the MPP side is saying aye, then he sitting in the chair will also shout aye. I mean, can you imagine?
I hear you. Come on. So, some say this is a clear case of the referee in the match swapping jersey to take the penalty shoot for the team to win. Is that the case?
Well, Johnny, once again, good morning, and good morning to my brothers, Kabila and Sam Jatta George, Honorable. Johnny, we all hold our views. We all have opinions. We are credited by our maker with some amount of reasoning as a people. That is why, Johnny, we do not run an acephalous society. We do not run a banana republic. We decide to say that, look, what Johnny thinks it suits him is what he thinks it is. What my brother Sam George thinks it suits him is what he thinks it is. Equally, Kabila and my good self. So because of the variance that we have, there's some anticipation of confusion going forward. Then we say, no banana republic. Let us now all sit down and have a gronum. And when I say the gronum, some will say the granum. That is the mother law of this country, the Constitution of the Republic of Ghana. Now, having had that, whatever that is inculcated in that particular document that is giving you a right and giving him a right and giving me a right and giving the viewer a right, then let us all use that document as a guide to protect ourselves. Okay. So that those various opinions that we have that you may think is dangerous and I think is not dangerous will not come to play. You know why I've set off by that?
No, tell me.
I'm trying to say that, look, we have all agreed per Article 2 of the Constitution of the Republic of Ghana that whoever thinks that there is something going on in this country, and before I even get there, let us bear in mind that Article 11 gives us a hierarchy of laws in this country. Take Article 11 and look at the first law. It talks about Constitution of Ghana. And then it ends up to tell you that any law that is inconsistent to the mother law of this country ceases to prevail. So where a law is enshrined in our constitution and an organic law, I call the organic law, I will add even some of the, with all respect to my parliamentarians, I would add their standing orders
okay,
as an organic law, because obviously it is emanating from the constitution. But that organic law can never prevail over the Constitution of the Republic of Ghana. And that is what we need to know fundamentally. First, we must have a guide. We must have laws protecting us. Secondly, we must all agree that yes, we all have our various views, but our views do not make up. Now, my good brother Sam George sits here.
What's the difficulty between the standing orders and the Constitution? Is it that the standing orders are not in sync with the Constitution?
I have read Article 110 of the Constitution of the Republic of Ghana, Article 110, which says that subject to this Constitution, Parliament shall make rules. I am not quoting but paraphrasing. Make rules to guide their own proceedings.
Right.
Okay? When you look at it, I am paraphrasing. Actually.
That's right.
Now, what one is, it says subject to this Constitution. Ab initio, it tells you that the Constitution is supreme. So, as and when somebody raises a question of your procedure and goes to the Supreme Court for interpretation per Article 12, Article 2, and then a pronouncement comes from the Supreme Court, it is binding on you. Again, it doesn't stop you from criticizing such judgment. Look, you see, the last time I checked, my good brother was with London University doing his law. I don't know, that's a long time ago anyway. And I know. And of course, I also tried a bit to do at Mount Crest to do some of my fundamental laws. But what I do know is that those fundamentals, we are told that clearly when a Supreme Court passes a judgment, it is binding on you, it is binding on me. But it doesn't stop us from criticizing the judgment constructively and on point of loss. You don't come to speak to emotions or speak with emotions. You are supposed to criticize a judgment if you are alleging a miscarriage of justice. Criticize the said judgment with point of loss, and we can move on. But that is not what we are saying. Somebody thinks that, why? Well, I have listened to so many commentaries. Somebody come to sit down, instead of juxtaposing your arguments, okay, or instead of backing your argument, I should say, backing your arguments with provisions of the laws of this country, with all respect, all someone will come and tell you is that once we are, the Constitution says that we can have our procedure, Parliament is its own master.
He quoted a certain law.
It's not him. I have listened to various commentaries. I'm not just referring to Sam George. But why? I listened to one of Semper or something, and I thought it was quite.
You didn't like the comment.
No, you see, that's why I said we have the right, or we reserve the right to criticize judgments of courts. Okay, and it is even good because that is why they say that the law is a living organism. Once it moves, obviously nobody can have it holistic in terms of saying that my comprehension is apt and that ends it. Obviously, it evolves. You have your views, I have my views, but the law is still the law. Right. So when it comes, criticize it, but criticize it on point of law.
He's, for example, questioning the credibility.
Yeah.
On one end, he's alleging that there's corruption that has been pointed out by leading members of, for example, the bar. He's also talking about the fact that it's become too monotonous. The Supreme Court becoming a unanimous FC. He's also spoken about the fact that the people have lost trust in the judiciary.
Addressing the bit of corruption, judicial corruption, judicial likelihood of bias, or whatever, did not start today.
When did it start?
It has always been the norm. Before even the inception of the Fourth Republican Constitution, we have had, of course, Article 179 of the Constitution tells you about judicial independence of the judiciary, or as it were. But of course, those questions have been raised whether there has been independence of the judiciary, and it's not arising today. So on corruption and on likelihood of bias, it has always been part of the suggestions or commentary that we make. Now, two, unanimous FC. Since when has it become a crime that justices of the Superior Court of Judicature sits down and all of them, the matter before them, say that, look, we agree or we concur with whatever reasoning that maybe the presiding justice has given? Since when has it become a crime? Is it part of the norm? Is it part of the procedures of court or not? Then somebody says, because today I am in opposition and I am opposed to a particular point, and then the justices of the Superior Court says that unanimously we have agreed on this matter, then of course I will allege corruption. Is that serious? Let's get serious, my brother. Let's get serious. The people we put there, and I agree with Sam George when he says the institutions should not be bastardized.
Right.
Okay? But decisions could be looked into and criticized. I agree, we have to criticize it. But in criticizing, I still maintain that we can do that with some amount of decorum.
Some members of parliament think this is an intrusion.
It cannot be. I just told you Article 110. My understanding is, look, this is rather a straightforward matter that went before the Supreme Court. I am surprised. That's why I'm saying that I am surprised. You see, the last time I checked, even in framing laws for this country or drafting laws in this country, the laws of Ghana, and in fact the principles established in law, sometimes encourages that we should even bring people who are not literate to be part of making laws. People who have never been to school. So it doesn't mean that when you can translate and you can transliterate, it means you are the best. Your language is not what it is. It's wisdom. So even the principle establishes that somebody who has not been to school, somebody who's not lettered, can sit or is supposed to sit to be part of people who draft laws in this country because of home reasoning. Okay? So I am saying here, that is why when you take Article 94, qualification to become a member of parliament, you don't need to go to school to be a member of parliament in this country.
That's right.
You don't need that. You can be a palm white tapper and come, and your people like you, they vote for you, come and sit down and make laws for us.
Same thing with the Minister of State.
I'm saying Article 94 is clear, but we sit here and we think that the person who is the best orator, who can speak all the English, who can bring us all the jargon, who can be verbose, such a person is the one who is credited with knowledge.
Is the MPP not worried about the repercussions, the fact that horns are being locked now? at the time when we're asking for consensus in a hung parliament?
First of all, it's not the MPP that took the matter to court. And let's set this record straight. Justice Abdullahi, the lawyer Justice Abdullahi, who took the matter to court, is not sponsored by the MPP to go to court.
Right.
First of all, it is a citizen of this country who is part of the industry, of legal industry in this country. Things that no. I have observed something going on in our parliament, which is supposed to strengthen our democracy. Let me go to the Supreme Court to seek for input. So when somebody thinks that it's MPP that took the matter to court, that person is only being untruthful to Ghanaians in this country. And it's not fair.
I'm asking of the repercussions. Are you not worried?
What are the repercussions?
Consensus. You've seen the hard stance of the minority. Your side also has, its own hard stance. We're asking for consensus in a hung parliament. And this could affect the business of parliament.
You see, Sam George is the member of parliament here. He is lucky to be one. And he will tell you and tell all of us that it is not just on a single matter.
He's lucky.
Wait a minute. Call e-levy that sometimes they disagree on. There are series of matters that they disagree on, even at committee levels. And they disagree to agree. Now, when you raise the issue of consensus, we have always advocated for all of us championing that cause, especially our members of parliament, because Ghana must be seen to be advancing. Okay? However, it doesn't also say that, we cannot disagree on matters when it comes up, as we have now, maybe the e-levy and some other issues that have actually come to the public domain. But I can say that, look, this Parliament of Ghana, and I want to credit them that, have actually worked with that spirit of, cooperation for a very long time, until we even got these numbers appearing to be hung.
Okay.
Are you getting me? So that has always been part of it. Let's give them that credit and move on.
I'll ask you a very final question. Yeah. Sorry. We have had constitutional review in this country. This seeming clash between the standing orders and the 1992 Constitution, do you get a sense it has ever been raised in any of the
I read Standing Order 109 Clause 3, which has actually been struck out by the Supreme Court today, and as we sit, because it ceases to exist. And you ask the question whether I see a clash between the standing orders, and then, of course, that's the argument out there, that Parliament is a master of its own, and we make our rules, and you cannot come to tell us what to do. However, we have forgotten that an express mention in the Constitution of Ghana, instructing Parliament to come up with their procedures. The same Constitution that you go to Supreme Court to seek for interpretation. That's what 110 tells you. Parliament has been instructed by this Constitution to come up with their procedures.
But can the court?
Wait a minute.
Can the court also
I'm answering your question. Let me answer
Can the court also dictate to cabinet how to run its affairs?
No. Why? The last time I checked, even the Constitution of Ghana tells the judiciary to draft their own rules. That is why we have civil law procedure.
Does it tell cabinet?
I'm saying that the last time I checked, when you take the Constitution, it tells the judiciary to come up with their procedures, and that procedure must be in tandem with the laws of Ghana, which is the Constitution.
No debate.
That is the subject.
Does it tell cabinet, President Akufo-Addo and his cabinet ministers, how to run their affairs?
You see, let us not get. You see, with all respect, I was saying this is chiddish.
Oh, is it?
I will.
Okay.
It is chiddish, completely. It is infantile for one to say that because it has not said that cabinet should run it, then this person come in. I am telling you, there's an express mention of a provision of the law.
Okay.
Which law says that Parliament, subject to this particular one, should come up with a procedure. So when you come up with a procedure which is found inimical to the mother law of Ghana, it stands to reason that the person who is supposed to check you or put you in check, that is why under separation of powers, we have what we call checks and balances.
I hear you.
It's not holistic.
Thank you. So, James, horns have been locked, obviously. Kwabena, what's on your mind?
Horns are not locked. We are only perceiving it to be so. It's not. This is a straightforward matter.
I hear you. Kwabena, what's on your mind?
Well, it's a bit worrying how we play ourselves to make it appear as though we are helpless. It's sad, especially the persons who have occupied the partisan political space under this fourth Republican dispensation. I did an article after the 2020 elections. And I made a point that God knows why the outcome of the election was that much. and that there was a lesson in it for us, if only we would learn. I can say without any equivocation that I doubt if we are learning.
Really?
We are not.
Why do you say that?
You see, the intransigence on the sides, majority, minority, government, opposition, is not helping anybody. We can't keep on riding our high horses and expect to build consensus. It won't happen. Nobody is entirely blameless. Nobody is entirely blamable. Nobody. You see, Johnny, the fact that Parliament is a master of its own rules is not synonymous to say that Parliament reserves the right to determine the constitutionality or otherwise of its rules. That is not theirs. That is the preserve of the Supreme Court. Parliament cannot. In fact, interpretation of the rules in Parliament per the Standing Order 5 are to be done by the Speaker as he deems fit. There was a Speaker who deemed it fit that he will not entertain private member motions.
Right.
A Speaker came and deemed it fit to admit private member motions, and today in this Parliament, right from the time of the Right Honourable Michael Quay, we now have private member bills.
Right.
Is that to suggest that though Ajaho, DF Annan, Bejina Sechi Hughes, and other Bamfado, is that to suggest that they were any less right honourable speakers of the House? Certainly not. But what they deemed fit was what they did. The Constitution and their own standing orders allowed that. If one alleges that the admittance or admission of private member bills by the Right Honourable Speaker Michael Quay and continued today by Right Honourable Alban Sumana Kingsford Bagwen is unconstitutional, that one, it won't lie in the mouth of Right Honourable Bagwen to make that pronouncement. It has to go to the Supreme Court. So we need to appreciate the distinction between being a master of his own rules and when the rules of which they are masters are questioned against the Constitution.
So then somebody would ask the question, the legislature has oversight responsibility of the executive. Executive will also come to the legislature sometimes to seek to have oversight responsibility.
Right.
Who has oversight responsibility over the judiciary?
The Parliament has, and the executive has.
Do you see them doing that?
Well, okay, so I'll come to that. You see, and that's why I'm saying that it hurts that we make it seem we are so helpless. It all boils down to our attitude. And that's why I often like to quote Hubert Humphrey, the former Vice President of the United States, in his academic days, 1965. His book titled The Cause is Mankind. He says, the law can be no better than the people who are called upon to obey or administer it.
Absolutely.
The law's written, and I always say that even I back the need for a constitutional review. I back it. But you see, I'm hesitating lately because no matter what law we evolve, if our commitment is not to adhere to it, it will be useless.
Needless. That's true.
We are not adhering to this Constitution. We are not. That's our problem. But you see, I have made the fundamental point about the difference that must be made.
Right.
Let me proceed to make this point. The decision of the Supreme Court, and I've heard my brother talk about unanimous FC. To some extent, our criticisms can extend into bastardization of the institution if we are not careful. It's a slippery ground. To what extent do we do that? Is this the first time there's a unanimous decision? I would love to read the reasoning of each individual judge, even when they are unanimous.
And that's where Sam George raises the question that it's becoming one too many, where you give a verdict, and then as a sequel, you bring the reasoning. Why can the reasoning not come with a verdict so it settles the dust?
As far as possible, that is a speculative comment.
Very.
I don't know which study he has conducted. No, I'm speaking from a research point of view.
Okay.
I don't know what study he has done from our coming into being as a nation from 1957. Decisions of Supreme Court that have where the ruling has been given and the judgment has been deferred to a subsequent time.
The reasoning, you mean?
Yeah, the reasoning behind that's what you call the judgment. When it has been deferred to another time. I don't know how many studies, how many cases have been studied, and how many of them you can conclude that in this caliber or this category are in the majority and these are in the minority. I haven't done that. I haven't seen that study. Okay. So that's why I say that it's speculative at this point. I would want to read or see an empirical study of that nature. But there's a history to some of these things. There are two cases of mine that went to the Supreme Court. They delayed their reasoning behind it. Yeah, it came thereafter. There are even times when the reasoning is ready, but they don't read it in full in court and say that it will be filed with the court registry for people to pick. Is it allowed? Yes, if it is allowed, let us not make too much of that. Now,
given the temperature in the country at this time.
You see,
at this time.
Again, that temperature is constructed.
By who?
Us. We live in a socially constructed world, my brother. How our panel discussion is going on here is constructed by the viewer. He may see that, oh, why is this guy talking so this or that? Oh, he's cool, calm. It's based on sometimes how we construct what we are seeing. Because don't forget that we are individual and our thinking and our constructions are based on our worldviews and our makeup.
Right.
So let's not leave that out. If we poison the atmosphere about something and people see it as poison, you cannot say that we are innocent of what we have created of that.
But there's also reality.
Of course.
There's a reality,
Johnny,
there's a public opinion.
Johnny, I'm coming. Right from independence, at which point in time have we said that the judiciary is above reproach in this country?
We've never said it.
There is something yesterday I was talking to my friend, my brother Sami Jamfi. Ray Akoto, in my view, it's a politically oriented lecture they do by the Bar Association every year. Because the issue, the trust of that matter in Ray Akoto is dead in our jurisprudence and our judicial activities today. You cannot hold an individual beyond a certain time and then not, try the person or put the person before the courts. The habeas corpus principle. Okay? Why do lawyers still continue to hold that Ray Akoto Memorial Lecture? It was political to make a certain regime look a certain way, in my view. Okay? But it's a right of the people. All I'm saying is that you can have issues with judgments. You can have issues with decisions of the court or the judges. However, you do not have that right to say that because I disagree with them today, it makes them, if you like, not performing the function.
So, Minority Leader Haruna Iddrisu, for example, says that this judgment is an endorsement judicially of the e-levy that the NPP government wants to impose.
As for the e-levy,
that's my final question. So we can come.
We see Johnny, you see, I want to make this point. If you look at the standing orders and the Constitution, the National Constitution, the Speaker, as the Speaker, the Right Honorable Speaker, the Right Honorable Speaker is the only one with that title, Right Honorable. The deputy speakers are not called Right Honorable Deputy Speakers. Do you know that? Okay. The manner in which the Speaker is elected is different from the manner in which the deputy speakers are elected.
That's right.
That's another point. The third point is this. I don't know why the framers made it a point. It's a fiat. The deputy speakers must be elected from among members of parliament, not belonging to one side. You see, it is not for nothing. as for presiding and voting at the same time, I have issues with that.
What are your issues? Quickly, so Sam George can.
No, I'm saying that I have issues. I have issues.
What
with
are
that.
your issues?
I said presiding and voting
Right.
at the same time.
Right.
And I don't think that is what the Supreme Court said. What the Supreme Court has said is that unlike the Speaker, who when he's presiding has no vote, the Deputy Speaker when he's presiding has a vote.
We are yet to see the reasoning. So
Good.
where are you
No, I'm
extrapolating
saying-
this from?
I'm saying that I am saying I don't have a right to express my view.
It's okay, but I'm saying let's stick to the reasoning.
Because
we have not seen it.
let me be honest with you, I am in agreement with the final decision of the Supreme Court.
Okay.
Because I felt that what our brothers were doing on the other side was hypocritic. And it was also because of the near hang nature of this parliament. That's why we have come to this. But it is not a helpless situation. We cannot wiggle our way out of it. Let us, with patience, calm, and appreciation of each other's point, listen to one another. I want to make this last point. If I had been elected into parliament in 2012, when I contested for my constituency, you know one of the things I was going to do? I was going to go straight to the Supreme Court right after election as a member of parliament to challenge the constitutionality of this standing order limiting the House to just minority and majority, on the grounds that if I had been elected then, I had been elected on a party that was going to be
the CPP.
Yes, on the ticket of, and I was not ready to go and sit with either NDC or the MPP.
So a special space should have been created for you.
Exactly. And this constitution guarantees that. Yet you have a standing order that does not guarantee that.
But you are allowed
So
to choose which side to do
Thank
business
you.
with.
Thank you. And I'm saying that is part of a problem, a conflict, if you like, between the standing orders and this national constitution. You see, let us not make a mistake to think that the standing orders,
Wrap up for me.
yes, the standing orders, just like the national constitution, is sacrosanct. Johnny, how many times have we not heard people say that we must review this national constitution?
Yeah, I've even reviewed the standing orders and amended them.
No, I'm coming.
Yeah.
How many times have we not? So if we can review the national constitution, the parent law, Abba, how can we continue to hold the view that if the Supreme Court decides in their wisdom at some point that something in this standing order should be struck out, that makes them a unanimous Chelsea FC.
Okay, I hear you.
And
You have not answered my
You should
question.
be
My
Chelsea.
question is, Minority Leader Haruna Iddrisu says this decision by the Supreme Court is an endorsement of the e-levy from a judicial point of view. What do you say?
That is his view, and if I were to respond to him quickly, I'll be wondering why he has been inconsistent in terms of the principle on e-levy. He once said that he was in agreement with the e-levy in principle.
But figures.
Why?
Allow him, please.
Why did he cow into submission? Miserable submission of his party's position that e-levy is a no-no. He should be addressing us, because you see, the hypocrisy of our country is what always is nauseating.
I hear you.
In principle, we are paying e-levy. I send mobile money to you, I pay a commission on that. It is not called e-levy, but I pay.
For a service rendered.
Yes.
But what would they...
Why government doesn't take anything from that? He is served in the Communication Committee of Parliament. That commission, when it is taken, is shared between the vendor and the telcos.
I hear you. Thank you. Sam, you have a rebuttal? If you don't, then we can move on to it.
Quite a number. A lot of things have been said.
We're moving on.
And let me
You want to have another mic?
let me just end from where he started.
Right.
Haruna Iddrisu has not flip-flopped. Haruna Iddrisu has represented the position of the NDC. The NDC was called upon by Ghanaians to go and sit and try and reach a compromise with the government on this matter. It was that possible compromise position that Haruna did communicate, that said, look, even if we want to do this, do it at a reduced level. Okay? Now, compromise is only achieved when one side shifts its position and the other side also shifts, and we meet in the middle. We came with a 0% thing. You came with 1.75. There was even the proposal of a 1%, which was supposed to be a middle ground, which you refused to move to. Government refused to move on. So at the end of the day, if you try to reach a compromise and the other side refuses to budge, and you say, okay, fine, I'm going back to my default position. How is that flip-flopping?
Well, government came to 1.5.
Not at the negotiation table.
Okay.
Okay, that was post the negotiation. So I just need to correct that. And then again, it is incorrect for you to suggest that we are paying e-levy. That when you pay the service fee, government doesn't take anything. That's not correct.
What does the government?
Government takes 17.5% VAT. Takes 2.5% NHIL, takes 2.5% debt, takes 1% coverage, and takes a corporate.
VAT is not e-levy.
Of the commission.
Yes, yes.
E-levy.
Allow.
VAT
is on its own.
No.
So relax.
No.
It allows some, because you see, Kabila suggested
made
that
a specific statement in the communication sector, which is not correct. That we pay a service fee and it is only shared between the MNOs and the agents, and that is not true. In fact, when you computate it, close to 25% of the value of the money. In fact, some of the calculations make it 40% of the value, because they pay a corporate service tax. The corporate tax of 25% is paid on that revenue. So it is not correct to suggest. It is not correct to suggest that when we pay to a service provider for a service rendered, that government takes taxes on that. That is the same thing as e-levy, because e-levy, again, e-levy is payment on monies that for service that government has not rendered. Again, when you even go to some of the telcos, some of the MNOs, when you do the transaction, there's no service fee.
Yes.
Yeah. There is absolutely no service fee.
Yeah.
You understand me? But in those telcos that don't charge, if you pass the e-levy, you would still need to charge.
Yes.
So absolutely, how do you tell me that it's the same? They cannot be one and the same. Now, on the point of law that was raised, okay,
right.
Let's be clear.
Regarding which of the points?
Kamal made the point that most of the commentary is emotional,
right,
not backed by
right,
law. It's not law based. Okay, I made reference to Article 1045 when I spoke earlier. 1045 talks about when a member of parliament would lose your right to vote on the floor of the house because of a conflict of interest.
But he said not you. He said other.
What does it say? Please.
He said other people.
A member who is 1045.
Yes.
A member who is a party to or a partner in a firm which is a party to a contract which the government shall declare his interest and shall not vote on any question relating to the contract. It is on the basis of this.
You made this point earlier.
Yes, it's on the basis of this that people took Honorable, my very good friend, Honorable Bobo Ejapa Mensah to case on the PDS agreement.
Right.
You understand? It is this principle.
Was company secretary for one of the.
So my argument here is this: that when you suggest, and mind you, Ejapa Mensah being on a company secretary was not the people of is this Sekondi that he represents. It was not those people who were on the board. But what this constitution is saying, it means that his people would not have had their voice heard because of his interest in there. That's why I'm asking that when you have the MP for Bekwai acting as first deputy speaker, and then he is supposed to vote on a matter where he clearly is biased towards his party's position, how then do you tell me that because of his people, for which he gets other benefits, he cannot be stopped from taking part in a vote that he is biased? It is this confusion that I am raising.
Alan, please note your...
Again, even when you go into our standing orders, and I'm glad Kabila read the standing order. Standing order 5. Standing order 5 is clear that the procedure of the House rests in the bosom of Mr. Speaker, not in the judge of the Supreme Court. Listen.
But if it is not in sync with the Constitution,
the Supreme Court will have interpretative powers. No, that's why the same Supreme Court, in a previous instance in the J.H. Mensah case, said to us that what happens in Parliament is a closed book. Parliament is master of his own proceedings. And said that it is the respect for the separation of powers. That is why, listen, when Parliament produces a document which is legislation, Parliament produces a document which is legislation. That is the output of Parliament. That is subject to judicial interpretation. That is why Parliament can pass a law. You can go to the Supreme Court. The Supreme Court can strike portions of the law out as being inconsistent with the Constitution.
Because it's the finished product.
That's the finished product of Parliament. But how Parliament conducts its business cannot be the role or the preserve of, cannot come under the instruction or supervision of the judiciary.
I hear you.
The same way Parliament would vet appointees to the Supreme Court. But Parliament cannot determine the procedure for the Judicial Service. The Judicial Service determines its own procedure. The same way Cabinet can pass an agreement, and the Supreme Court would look at the result of Cabinet's meeting and say that this contract agreement Cabinet has gone into is unconstitutional or must go before Parliament because it needs to sit with 1815.
I hear you.
Parliament, but Cabinet, what they cannot do to Cabinet is to tell the President that when you go to Cabinet, let Dr. Bawumia be the one to chair issues of economic issues because he's the head of economic management team. No, but you cannot dictate to the President in his cabinet that this person should preside and this should be how you should conduct the business in cabinet.
Okay.
What you can do, what the judiciary can do, is to interrogate and subject the output of the executive and the legislature. But as to how we conduct our businesses,
Procedure.
it is not the business.
Sam, let me ask you this.
Come
I'll come to you. Let me ask. Our time is running out, but let me ask you this quickly. Your leadership in Parliament promised us at the beginning of this session that we will not have any brawl, and they emphatically apologized for what had happened at the beginning of 2021 and at the end of 2021. Are we heading towards another brawl?
I have never had a time when the leadership of Parliament, and I can speak of the minority, called us and said, today we are going into a meeting, we are going to fight. Never.
So even though you have been leading the charge.
I'm not suggesting that. I'm not suggesting that.
I take strong exception.
I'm not suggesting that.
Sam, that's a very good answer to his question.
No, I'm just asking.
He's giving a good answer.
I'm just asking.
They have never called us and said, go and fight.
That's why I'm not asking them. I'm asking you.
However, members of Parliament swear an oath to defend the Constitution.
Absolutely.
Right.
Okay, and in defense of the Constitution, Article 3 is clear.
Says to go and fight.
Article 3 says, even when murder is committed in defense of the Constitution,
It's no crime.
it's no crime. So all I can say is that the 137 members of Parliament on the NDC side are passionate about ensuring that no illegality, be it to the Constitution or the standing orders of Parliament, is perpetrated on the floor of the House. That is the promise we make.
Come on, step in. Kamila, you have your turn. You have the final word.
Interestingly, we all choose to interpret the laws the way we think it suits us.
Right.
Okay? And that is why I believe the framers of this constitution, okay, in their wisdom, said that leave the interpretation of same to a body that we all agree, and whatever comes out of it, that same law says that not even the president, not even the vice president, in fact, it will even constitute a ground for his removal as president if he doesn't obey the Supreme Court. Okay? So, when my brother takes Article 1045 and talks about a firm having a party, blah, 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 and that you wouldn't vote. You see, what is actually on the table? Are deputy speakers members of Parliament or not? It's a question to ask.
They are.
They are. Are members of Parliament supposed to vote on matters or motions in Parliament or not?
The timing.
Timing. I agree. No, I agree. Timing.
If they are in
That
the
is
chair,
why
they
they
can't
say.
vote.
You see, and I like when Kabila chose his words well. He says he is actually against presiding
And voting.
and voting.
And I don't think that is what the Supreme Court
And that is not what the Supreme Court said.
We have not
You see,
seen the reasoning.
How are you guys joining this conclusion when you haven't seen
You
it?
have not seen the
That's why I'm
reasoning.
questioning why we don't
The
see the
Supreme
reasoning.
Court, the matter before the Supreme Court was to whether or not deputy speakers could vote.
But
in
you need
Parliament
to see
or
the
could be
reasoning
counted.
to be able to come to
But
that conclusion.
I listened to the Sam George's press conference when the minority leader says that.
I'm not addressing the press
I am
conference.
not.
I'm here. I'm moderating a
We
forum.
are having a discussion. And
Right.
I'm making reference.
I'm not
to
part of the
certain comments that
discussion. I'm the speaker here.
I love that. I love that. I love that.
So you are master on your own.
I don't have a voting right.
The right honorable
You see,
speaker.
the point I
Thank
want
you.
to make is that there's when we realize that there's some absurdity, some unconstitutionality with certain provisions of it, we go there and they seek interpretation. We are directed to do what is right and we come back. But the fundamental question is that the people of Bekwai, the people of Fomena, do they have a representation in Parliament? If the answer is yes, and when it comes to counting on a motion to be taken per Article 104, as we have it, are they supposed to be counted or not? This is the matter before the Supreme Court. Supreme Court says, yes, they are supposed to be counted.
Okay.
You see, let us move on. But I will also say that, look, the emotions I spoke about clearly includes the e-levy comment. The emotions I spoke about includes the e-levy comment by the minority leader. Hello?
Yes.
I'm saying the emotions I spoke about includes the e-levy comment
By Haruna Idrisu.
by Haruna Idrisu, when he sought to say that the judiciary subtly had supported what we call the e-levy bill
not
before
entitled to his
And
opinion?
For me, that's why I say it's emotions. Because even the matter before the Supreme Court had nothing to do with e-levy.
I hear you. Kabila.
Even emotions, what it is.
Kabila, you have the final word.
Johnny,
Before we eat the two.
Johnny, even the cabinets of the Republic, headed by the president, is subject to decisions of the Supreme Court.
Not the procedure.
Of course, that's what I'm saying. I began by saying that that procedure, if it is so done unconstitutionally, can be pronounced upon by the Supreme Court.
That's all.
Make no mistake about it. You see, it is not for nothing that we have put. Come on. It is not for nothing that we have put certain things in the Constitution as it is. Two things I want to clear.
Quickly.
One, our Parliament is not sovereign. Even the UK House of Lords, Parliament, the UK Parliament, that was sovereign since 2009. It is no more sovereign since they created the Supreme Court. Okay, now the decisions of that house are subject to the decisions of the Supreme Court. Then the other point I want to make is this, Johnny. Minority decisions previously made have traveled a long way to find themselves not only to be persuasive but to assume majority positions.
Okay.
True or false?
True. Right.
Obita decisions have
become the ratio. The ratio decidendi. It is just a matter of time. So why do we get so impatient when a decision has gone against us and we believe in the force of logic and yet we are so much in a rush to bastardize?
I hear you.
That is
Thank you very much.
It is not sustainable. Let us
go to Facebook and write.
Please.
Who wrote it?
Let us remember. Let us remember that
I'm sure that's why he brought the ball.
nations are built. Nations are built with two critical ingredients: long-suffering and patience.
Thank you. James Kwabena Bonfe, he is the editor of the National Forum, managing editor of the National Forum, big position. And also Kamal Dean Abdullahi, he is a deputy national communications director of the NPP. And also Sam Jatta George, he is the member of parliament for the Ningo Pram constituency. You did the ground there. Okay, I hear you. Let's say a happy birthday. I'm coming from the wife and children of Professor Ernesto Foriata of End Time Revival Center, Assemblies of God Church, Adenta Estate. Today is your 70th birthday. Happy birthday to you. They say they love you. Also to Nidromo Ayi Okain of Ideal Community School, North Kaneshie, from your dad, Mr. Samuel Ayi Okain, and your mom as well. They wish you all the best. And Mrs. Natasha Na Adoko Ayite, from your husband and the entire family. Happy birthday to you. Also to Mr. Daniel Achu. He is with our technical department here. We call him Chairman. It's your birthday today, Chamano. Happy birthday to you. And happy birthday to Jennifer Kwansma Korte. Happy birthday to you as well. Hamdallah, the GIJ. We're going to eat our tuwo, and we're going to eat it in a zafi whip because it has to be hot. Yeah, so that's what we're going to do right now. But thank you, gentlemen, for your time.
So you brought us to talk.
Yeah.
Now when it's time for food, we are
No. We are taking.